The National Green Tribunal was established in 2010, essentially as a dedicated specialized agency whose primary job is to ensure that you are able to effectively dispose of cases which are related to the protection and the environment of forests and other natural resources. We also understand that tribunal has jurisdiction over all cases involving substantial questions of law or substantial questions of the environment, including enforcement of any right relating to the environment. Now, you must understand that environmental jurisprudence or environmental law per se, though has been in the country for more than 2 decades with the Environment Protection Act and all of that, but in terms of evolving the law, it's still a very, very young law. We've seen a lot of judgments on implications of it, but the law still has a very long way to be evolved. Now, why is this so special? Because India is the third country in the world, apart from Australia and New Zealand, to have a dedicated court system for addressing environmental concerns. It has a principal bench in Delhi, and it has regional benches in Pune, Bhopal, Chennai, and Kolkata. And cases from the National Green Tribunal are appealed to the Supreme Court. Now, what are your fundamental challenges with respect to the National Green Tribunal? See, the idea is the two important acts that we refer to, the Wildlife Protection Act 1972 and the ST and Forest Dwellers Recognition of Rights Act of 2006. These two rights, these two laws, and issues arising out of these two laws are not under the purview of the National Green Tribunal. And most of your environmental violations in terms of taking consent, in terms of involving stakeholders in certain infrastructure developments concerning these areas, they are not able to be reviewed by the respective tribunals. And it largely deals with the Environmental Protection Act of 1986, right? Okay. Governance, of course, I've already explained. Please have a look at the YouTube video. I've already explained. I will make a full YouTube series on governance, which will be enough for everybody. Okay? So don't worry about it. Now, that's the first part. The second part is what exactly is the appellate procedure? Now, I told you that some cases can go to the Supreme Court, and there are, depending on the nature and the cost of the case, in some cases, the appellate jurisdiction may lie with the National Green Tribunal. So there is a lack of clarity in the positioning of National Green Tribunals with respect to high courts. And therefore, what happens is some of the times the cases end up being appealed to the high courts, which could be a procedural issue. And in most cases, the appeals from the National Green Tribunal should essentially be going to the Supreme Court. So there's a lack of clarity with respect to the High Court positioning, and therefore it results in sometimes the government or the other party appealing these decisions in the high courts under 226, that high courts are superior under 226 to the green tribunals because high courts have writ powers. While the NGT Act, as I told you clearly, provides for a direct appeal to the Supreme Court, and therefore making things slightly complicated in terms of where would the cases be appealed to. And apart from that, the decisions of the National Green Tribunal are not fully complied with by the stakeholders or the government under the pretext of an unfeasible sort of a time frame. For example, in yesterday's Indian Express, by extension to today's Indian Express also, the Indian Express team of investigative journalists have conducted an express investigation where they have found out that 6 mega infrastructure projects which have been given clearances were given on certain conditions that have not been met, such as afforestation and other related measures. Now, apart from this, while the National Green Tribunal is a dedicated and a specialized tribunal, it still does not get the human resources and the financial impetus to support its functioning, and therefore it is not able to quickly, accurately, and with the kind of expertise in law it should have process cases in the manner that it should. Now, there have been a few landmark cases with respect to the National Green Tribunals. Let's look at some of these landmark cases. So, first was, in fact, Betty Alvarez versus the state of Goa. In this, it was held that even a foreign national who experiences and or who is able to identify an environmental compliance problem or a violation problem can approach the National Green Tribunal. In Almitra Patel and Union of India, there was a complete prohibition on the burning of waste on lands, and we all know how well this is complied. It is not complied properly. Manoj Mishra versus the Delhi Development Authority. In this, very popularly, this was called the Art of Living case. And in what basically happened was they had conducted in Noida, on the banks of the river Yamuna, an art of living cultural festival, an art of living, what is called a celebratory festival where all the world leaders, and there were huge programs that happened, but it ended up excessively damaging the ecosystem, and the NGT had sort of fined them to the tune of about 5 crores. So these have been some of the cases which have been in the limelight since the Green Tribunal has been come into question. You can keep adding these cases as and when they come in the newspapers. What is very interesting to note is that the NGT has also started using suo motu powers. Now, suo motu powers is that you don't have to go to a court for the court to look into the matter. Sometimes the courts on their own can take cognizance of a matter, register a case, and call up the government usually to give a response to the matter. This is called suo motu. For example, the most recent suo motu case that the Supreme Court had taken up was with respect to the management of health in COVID, and that was in last year when the Supreme Court had taken up the COVID litigation. So suo motu powers are quite exercised every now and then. So what happened last year also was in October 2021 in the Municipal Corporation of Bombay versus Ankita Sinha, the court had very clearly, the Supreme Court had very clearly decided that the National Green Tribunal has suo motu powers because the nature of work is such that it may have to take up certain stern actions in the best interest of society. And therefore, NGT was formed to protect a key element of the right to life, which is the right to a safe and a healthy environment. Now, Section 14, you may not remember the section eventually, but just to give you a context, Section 14 of the NGT Act very clearly states that for the NGT to be able to hear a matter, there must be a civil case which substantially concerns the environment and involves the implementation of environmental legislations. Then, if you're able to satisfy each of these three, then the NGT can exercise jurisdiction, which also very clearly tells you NGT does not have the powers to send you to jail. It is not a criminal court. So your CRPC and other criminal laws also do not apply, which also means that you can't go to the NGT and say that we want the person to go to jail. And well, if you think about it, environmental degradations are nothing short of, in fact, a criminal offense. Okay. Now, a lot of times people assume that, there is an issue with compliance, there's an issue with environmental impact assessments, there is an issue with implementing a project, keeping environmental regulations in mind. But you must understand it goes way beyond that kind of a dispute resolution. What it looks into is upholding the absolute unquestionable ability of a person to live in a healthy ecosystem. And that's the role, and that's the philosophical and the larger origin of the role of the National Green Tribunal. And the court has therefore held that as long as that sphere of action to uphold environmental jurisprudence is not breached, the NGT powers must be read as widely as possible. And of course, the NGT should be guided by the principles of environmental justice and equity. So there were a few things that happened, which is why this was brought into question. Now, once we've understood this, this then prompts us to understanding the larger issue that we often discuss and debate with, and this is a hot topic with civil services aspirants as well, and I'll come to that. See, if you get a question which says, should NGT have suo motu powers? I've given you enough content to say that yes, the law provides for the same, the Supreme Court provides for the same, which is why you will not get a question like this. You will never get a question in terms of should NGT be given suo motu powers, largely because the law and the Supreme Court have very clearly established that you should. Now, you should do it in the interest of environmental justice and equity and not breach that sort of a line. That's completely fine. That's exactly how it should be. Now, the first thing you must understand is judicial review in a more advanced form is activism. And you must also understand what is activism for me may not be activism for you. What is activism for you may not be activism for me. So there is no hard and fast rule to this. However, we will look into certain cases, we look into certain examples and see what it is that we're trying to do. Now, the fundamental objectives of judicial review are twofold. One is that it legitimizes government action. See, judicial review is, there is a law, you're questioning the validity of the law. Doesn't matter what kind of law, doesn't matter how was the law passed. If there is a law, you're questioning the validity of the law. And by the government upholding the law, if the court upholds the law, then you are basically giving legitimacy to government action. Or you're informing the government that your law is valid. If not, then we'll obviously strike it down. And the second is, you have to make sure that the fundamental premise of having a constitution or a constitutional supremacy is that the government cannot make any law which violates certain principles of the constitution, the basic structure doctrine that we've discussed, and very specifically, you cannot violate anything which is violating Part 3, which is fundamental rights of the Constitution. Now, if somebody ends up doing either of these two things, then it is legitimate for the government to get into questioning the objectives of the law, questioning the nature of the law, right? So that is the basic origin, and that is the basic reason why you would have judicial review in the first place. So when we do talk about judicial review, what we do understand is that the ultimate power of the judiciary to review and determine validity of a law or an order. That's why the law has been created. That's why the law is there in the first place. Okay? Now, the power of the court as to whether a law or an executive order or any other official action, it conflicts with the Constitution, then the court concludes what it does to therefore declare what is constitutional and what is not, what is void and what is not. And that is how judicial review is nothing but an application of separation of powers. Now, before we get into this, I'd want to refresh a very core concept for you. See, Article 13, Clause 2 says, no law can violate fundamental rights. And Kesananda Bharti has very clearly established, it has very clearly established that constitutional amendments are not law. This would then mean that constitutional amendments can violate fundamental rights. But to support this, Kesananda Bharti also says you cannot make any law that violates the basic structure, and this basic structure is determined by the Supreme Court, on a case-to-case basis, and as it is evolved by the Supreme Court from case to case. Okay? Now, this means if I apply and merge these two, a constitutional amendment can violate FR if it's not basic structure, and therefore it can't violate an FR if it is basic structure. So this is how precise the law is, right? Now, we've discussed this before, so we're okay with this. Now, you can take a minute to copy this down. We'll come to that. Okay. Now, let's understand why you would need this. Just because you get questions in the mains exam, like what is the importance of judicial review, like they asked it in the IR Coelho case. Now, there are 4 basic reasons as to why you would need them to begin with. First is the supremacy of the Constitution. See, the Constitution is over and above the legislature, the executive, and the judiciary. And the primary lawmaking power lies with the legislature. Now, how do we make sure that the laws that are made by the legislature are not violating what the Constitution had originally set out for? Okay. How do we make sure that the laws which have been made by the legislature are not violating the Constitution that we originally set out for? Right? Now, for those very specific reasons, you can't ask the executive because the executive is a subset of the legislature. So the only person who's left to keep a check on the laws which have been made by the legislature is in fact the Supreme Court. So that is why, to uphold the supremacy of the Constitution, wherein the Supreme Court is often considered as the guardian of the Constitution. There was a previous year prelims question on this also, upholding the rule of law and by declaring any action void if it violates the Constitution, and also limits the arbitrary powers of the government in upholding constitutionalism. Now that we understand this, we then would also understand that this is exactly how you ensure separation of powers by checks and balances, because it is the judiciary who's basically striking down a law made by the legislature, and that law could be drafted by the elected executive also. So that is how. And that is how you're able to keep a check on the legislature and the executive by keeping some constraints, by deciding what is right and what is wrong. Like, for example, right now, the Punjab and Haryana High Court have stayed the local reservation law in Haryana because the law wants to reserve jobs for the private sector in Haryana on the basis of domicile. Now, Article 16 very clearly says you can do so for descent, residence, caste, religion, race, sex, and place of birth. It doesn't mention domicile, and they've strictly used domicile as a criteria. So that's why. Now, the more advanced understanding of it is how it helps to maintain what is called a federal equilibrium or a federally safe ecosystem. See, you must understand that we have a federal country wherein there's the central government and the state government. Now, both the central and the state government are going to make a certain number of laws. Now, for example, there is a concurrent list. And in the concurrent list, like I'll give you the NEET example, right? Very interesting. See, what has happened is NEET is your national entrance test for undergraduate and postgraduate medical education. Now, education as a subject is in the concurrent list. However, regulation of higher education is in the union list. Regulation of higher education is in the union list. Now, when we talk about the undergraduate entrance test, it is before higher education begins and it is after school education finishes. So while education, a part of it is in the concurrent list and a part of it is in the union list, there seems to be some sort of a lack of a clarity. And that is why Tamil Nadu passes a bill saying that we are going to only look at +2, which is 12th marks, to get admissions to undergraduate medical education. And basically, they are not going to take up NEET as a criteria for Tamil Nadu owned or state of government or government of Tamil Nadu owned medical courses. Now, the governor, of course, has returned the bill like the governor can. And if this ends up in court, this is one of the reasons why it will end up in court. Because if you think about it, who else will decide? The center will have their say that, boss, this is leading to higher education. We have the powers to do this. You don't have the power to reject what we've tried to do. The state government is going to say, boss, higher education hasn't started yet. It starts once undergraduate medical education begins. So therefore, there is a little bit of a gap. And this is where the role of the Supreme Court becomes important, and the Supreme Court then steps in for this role. So this is very, very interesting. Okay. Now, in the case of inconsistency between these laws or the question of competency of lawmaking, there should be an impartial body, and that is why the impartial body happens to be the courts, and that is why judicial review becomes important. Right? Now, while the Constitution guarantees fundamental rights, which basically have to be enforced through a law and through executive action, whether the law is upholding fundamental rights or not, or whether the law is violating them or not, again has to be answered through an impartial body. You can't go back to the government and say, do you think you are implementing fundamental rights well enough? It is like asking you to correct your own mains papers, and you would all get a rank 1 in that case, which is why you have to take it to a court, and the court therefore is able to answer to your questions very, very clearly. Okay. Now, let's look at activism. Judicial review is okay. There is a law that exists and you are challenging the law. Now is where the judiciary is going to step into the shoes of the other two organs. It's going to transgress the separation of powers principle. So if it's going to transgress the separation of powers principle, let us look at this from that specific point of view. So what is it? First, Why do you need judicial activism? It is the failure of the other organs in discharging their duties. I'll give you some examples, right? Today, we have what is called the Prevention Against Sexual Harassment at Workplace Act for women, right? We have this law. This law is not even 10 years old, right? But sexual harassment against women at workplace is a reality of the Indian workplace. The parliament should have made a law on this several decades ago. It did not. And when a case happened called Vishakha versus State of Rajasthan, right? Vishakha versus State of Rajasthan, the Supreme Court no, this was, a case of harassment. The Supreme Court, in this case, gave a judgment, and in the judgment, gave guidelines that had to be implemented across all offices in the country. Now, the Supreme Court did this because there was no existing law here. The Supreme Court did tell the Parliament that as much as possible, whenever possible, please make a dedicated law on it. But the incompetency of the other two branches of government is why something like this exists in the first place, right? And that's the point. And many times, several laws and schemes in the social and economic sectors have remained mere declarations of good intentions, or they have not existed in the first place. And when that happens, the confidence of the citizens in the constitutional values, of course, erodes. And that is why the judiciary sort of steps in to make more precise and more concise laws for the government, for the people, and for the nation at large. And second is, very often the law does not exist in the first place. Either the laws are not effective enough, or the laws don't exist in the first place. So if the laws are not effective enough, then the Supreme Court interprets them in the right way so that they can be implemented in the right manner, or they are not effective enough to the point that they're just statements of ideas and all talk and no walk. And that's the problem, right? So two reasons. One, of course, is superficial laws, and second, non-existent laws, right? These are the two fundamental reasons why judicial review and judicial activism could largely exist. Okay, now, what is it that judicial review happens on, and what is it that it doesn't happen on? See, usually, whenever there is an action which violates fundamental rights, it could be through a law, it could be through an executive order, it could be through a scheme, it could be anything. But if it's violating fundamental rights, then you will, of course, challenge the same in the court, right? Like, for example, today there is an Indian Express explained on the freedom of religion, has something to do with some schools not allowing women to wear a burqa. That's where the controversy originates from. And then, of course, the Indian Express explained article does tell you that, in the army there are rules which say that keeping a beard is not an essential practice. So even if somebody who's Muslim and has a beard in the army, you are not allowed to keep the beard. So these are some of the ways that, rights issues come to the fore. Now, apart from this, if there are other legal right violations, apart from this, if there are any other laws or executive actions, in case there is a delegated legislation, a rule or an order, a lot of times, lockdown orders were challenged. A lot of times curfew orders get challenged. So those also. And of course, and if you are violating the reasonable restrictions that have been given, or you're misinterpreting the reasonable restrictions, that your reasonable restriction to Article 19 was decency and morality, but that does not give you the license, to criminalize homosexuality. So over a course of time, this also becomes important, right? Then what are your basic features here? See, I've now explained this to you when we did 32 and 226 also. So under 32 and 226, which is for fundamental rights and for fundamental rights and legal rights, 32 is for the Supreme Court and 226 is for the High Court. You can question the validity of a law. You can question the validity of the law under Articles 32 and 226, which is why both the Supreme Court and the High Court also have the powers. Of course, the Supreme Court is the final and the ultimate authority to do so, but you can also go to the High Courts as well. That and it's also sometimes that's also sometimes why it happens. So your local reservation law was first challenged in the Punjab Haryana High Court. They could do so because it was violating Article 16, which is a fundamental right, and that's why it reached the Punjab Haryana High Court. For those of you who are not able to get that part right, Punjab Haryana have one common High Court. Okay, so both the Supreme Court and High Courts exercise the power of judicial review, but the ultimate power, of course, lies with the Supreme Court. Apart from this, you can also conduct judicial review for all central and state laws, and you must understand this is an extremely important fact. Judicial review is only for questions of law, not questions of fact. So, what is a question of law and what is a question of fact? Suppose I am walking on the road and somebody stabs me with a knife. Did somebody stab me with a knife or not? That is a question of fact. Is stabbing me with a knife a criminal offense or not? Or is an offense or not? That is a question of law. That is a fundamental difference between a question of fact and a question of law. And that's exactly what is meant here. That you can question the law, not a specific incident which led to the law, right? So for example, and this is exactly what happens. When, let us say, a school bans a burqa, what the court will look into is banning the burqa a violation of a fundamental right or not? Did the school ban the burqa or not? That is okay. That is not our problem. We are here to make the larger law. If the schools can't ban the burqa, then the incident automatically becomes invalid and they will not be able to ban it any further. So that is something you must understand, right? Apart from this, you must understand that judicial review cannot be conducted in subjects which are in the 9th schedule unless, of course, they violate basic structure. This is the I.R. Coelho judgment. This is also one of the reasons why a Tamil Nadu reservation law, which allows for reservation in Tamil Nadu to be beyond 50%, which goes against the guidelines by Indira Sawhney, can't be challenged in a court of law because reservation is not basic structure, and reservation for Tamil Nadu, that specific state law, has been put into the 9th schedule, right? And judicial review it cannot be taken suo motu by the courts. So for example, in the COVID litigation, when the Supreme Court took a suo motu COVID case, there was no law. There was no violation of a law. They were largely looking at the management and the mismanagement of administration with respect to effectively handling COVID. So these are some basic principles that we must always know and understand, right? Now, there are certain advantages and there are certain disadvantages. So of course, the advantages are that they keep powers in check. It is for protection of people's rights. It also secures the independence of the judiciary, and it also helps the court exercise their constitutional duty. Very simple, very self-explanatory, right? However, at the end of the day, the court is an appointed body. It's not even a semi-elected body like the US judicial higher judicial system. So if it's not even a semi-elected body and they are deciding whether a law which is made by the democratic temple called the parliament or the legislatures are valid or not, okay, that's where the issue sort of lies. Okay. Now, therefore, it is also not very clearly defined. There is no there is no guidelines that these are ABCD laws can be looked into, DEF laws can't be looked into. It depends on the judge. It depends on the larger political system prevailing at the time, and so on and so forth. And of course, this could also lead to a judicial tyranny. I mean, think about it. If a military rule is a problem, so is a judicial rule. With all due respect to the judiciary, the 99th constitutional amendment, which was supposed to create the National Judicial Appointments Commission, which would basically be a body comprising of the Chief Justice of India, two other Supreme Court judges, would comprise of the law minister, would comprise of two jurists who would be nominated by the Prime Minister, the leader of opposition, and the CJI. They would collectively be responsible for the appointment and the transfer of Supreme Court and High Court judges, and they would have a veto power if even if two vetoes were cast in this process, then the appointment or the transfer would not go through. This seemed to be a fairly transparent process, but the Supreme Court said this may put the Supreme Court or the judiciary at a disadvantage, because if the law minister and even one of the jurists take a combined stand, then they can overrule Supreme Court recommendations on its own appointment, and therefore the Supreme Court struck down the 99th constitutional amendment in very recently. So this of course becomes an issue here. This is what ends up being a problem here. Okay, are we clear on this? Understood? Okay. So this is how it is, and it also reverses previous decisions. Like for example, Golaknath case reversed the earlier judgments of Shankari Prasad Sajjan Singh. Kesavananda Bharti reversed Golaknath. So what happens is there is always some form of inconsistency in judgments. Now this could have been for a good cause, I understand that, but a lot of times the Supreme Court will, or the High Court in fact, will overrule its previous judgments, and therefore things become slightly more complex. Okay, things become slightly more complex. Okay, are we okay with this? Do we understand this? Right? Okay. Now, what is the difference between the two, and how do we understand the difference between the two? Okay. Now, I've also introduced a new term called judicial overreach, which is also often asked, which you can always refer to. So, we're looking at three terms. First, judicial review. Second, judicial activism. And third, judicial overreach. Now, understand what this is. Judicial review is for existing laws and checking the validity of existing laws. Judicial activism is if the law is not being enforced properly, there is an issue with the implementation of it. It is more to do with social justice. It's connected to do with enforceability. And a more advanced form of judicial activism is judicial overreach. In your exams, you can write both of them as together also. There's no problem with that. This is where the Supreme Court or the High Court literally steps into the shoes of the legislature and the executive. This is where judicial legislations such as your Vishakha case come into being, right? Judicial legislations, the guidelines that are issued, that this is the law and this is how you have to go about it. Okay. Now you can do this because of Article 13 that says no law can be violative of a fundamental right, and you of course have 32 and 226 for enforcement of rights violations, right? Now apart from this, activism, and by the way, none of these words, the words judicial review, judicial activism, and judicial overreach, none of these words are defined in the Constitution. None of these words are defined in the Constitution. So even if in the prelims they ask you, under the Constitution, judicial review is defined under 32, that is an incorrect answer. It is not defined anywhere. These words are not mentioned in the Constitution, like how federalism is not mentioned, like how doctrine of basic structure is not mentioned, how colorable legislation is not mentioned. None of these words are actually mentioned in the Constitution. Okay. Anyways, so that is that. Now, as far as judicial activism is concerned, of course, there is no constitutional backing, and this is not desirable at all. It's not something that we should really be very happy about. This is a last resort. We are forced to accept this, and I understand that this has made the courts our messiah and we're very happy about it, but just think about it. It's because we as electors, as voters, have failed. We as the people of the country have failed, which is why the judiciary has to come and save us, do the job of the parliament for the parliament without being the parliament. And that's where the larger problem lies. That's where the slip between the cup and the lip lies. This is why we have failed, us in the domain that we've failed us. Now, there are several examples with respect to this. So, for example, Section 66A of the IT Act. For example, challenging the constitutionality of sedition, Section 124A. These are classic cases of judicial review. The Haryana reservation case, a classic case of a judicial review. X law is challenged in Y court. Simple as that. However, activism, that the implementation of the Constitution, the ethos of the Constitution, basic structure, the fact that locus standi may not necessarily be needed. You can come to court on behalf of a larger number of people for a common cause. This is public interest litigation. Similarly, if you have, for example, the law says that smoking has to be prohibitive. You are implementing the law in a better way by saying smoking should be banned in public places. Of course, I stand guilty of some of these laws. Anyways, and then, for example, let us say in activism, the Allahabad High Court in 2015 said it's compulsory for bureaucrats to send their children to government schools. Really, nobody's ever going to manage that. All cinema halls must play the national anthem before the screening of a film. You have no business doing this. Makes no difference. Don't bother with this. So these are some of the examples that you can use, and as I said, you can club both of them in the exam also. If it does not specifically mention overreach, then you can club activism and overreach together, and that's also fine. Okay? Now, let's look at some judgments and let's understand how these judgments have come into play. First, in Sampath Kumar versus Union of India, we've discussed this in tribunals. Bhagwati, who's also the hallmarks of PILs in India, established that judicial review was a basic feature of the Constitution. This was with respect to certain powers of certain tribunals. Similarly, in the L. Chandra Kumar case, which we discussed, the bench also stated that the power of judicial review over legislative action is under 226 and 32, and it's integral and essential feature of the Constitution, therefore its basic structure. So basically what had happened was the government had made certain rules with respect to how tribunal judgments could not be challenged in the court. So that is how the court said, ऐसे कैसे, basic structure is essential and you cannot challenge that in the larger way, right? I'm sorry, I'm limping a bit today because I have I think sprained my ankle. Anyways, and of course, very recently in the Navteej Singh Johar versus Union of India case, the Supreme Court decriminalized homosexuality by reading down the existing section of 377. We've covered this in Article 19 and 21. This is the Sabrimala case, the Indian Young Lawyers Association. Now, these are examples of judicial activism. This is where you're looking at the enforcement of a law. This is where you're looking at the objective of a law. And here you allowed the entry of women in the menstruating age group to the Sabrimala temple. In the Puttaswamy judgment, you have evolved the law. You said privacy is a fundamental right under Article 21. This you further apply with the current Pegasus case, which is Manohar Lal Sharma. It is currently pending. It's a Pegasus case. The Manohar Lal Sharma versus Union of India. The Supreme Court has set up a committee only, that we will set up a committee and we will tell you whether this has happened or not. This was in the news yesterday because only 2 mobile devices have been submitted to the Supreme Court committee, which is examining the use of Pegasus. Apart from this, you've got Vishakha versus State of Rajasthan, where the Supreme Court has laid down certain guidelines for prevention of workplace. And this judicial legislation, which is a form of judicial activism, was in place for 16 years. And it's only 2013 that we've had the sexual harassment prevention law at workplace in India, right? Now, let's go further and then see our constitutional provisions in detail, right? These are things that you should be able to write in the exam. ये exam के point of view से important है. I've already told you Article 13 and 226. Now see Articles 131 and 136. Articles 131 to 136, this also includes special leave petitions. I'll cover them what in judiciary, but just to give you a little bit of context, 136 is a special kind of power given to the Supreme Court. This is called special leave petition, which is any case currently going on in a lower court, any lower court including the High Court, can directly be transferred to the Supreme Court if there is a substantial question of law involved or gross violation of justice, so to speak. Okay. Now, from Articles 131 to 136, it basically entrusts the Supreme Court to decide disputes between the center and the state, and the courts will be required to interpret the provisions of the Constitution, and the interpretation by the Supreme Court must be honored by all courts of the land. Article 143 is again something we'll discuss in detail with respect to the Supreme Court. This is nothing but what is called advisory jurisdiction of the Supreme Court, where the President can seek advice from the Supreme Court. And why the President? Because of rule number 4, checks and balances. He's the only person who has one of the highest democratic mandates and is apolitical by nature, and that is why can ask the Supreme Court for their opinion. Now, in this case, the Supreme Court has 2 kinds of opinions on 2 kinds of issues. One in which the Supreme Court can say no, and in one case the Supreme Court has to necessarily give an opinion. Okay. Now, yes, Ekansh, very good. So Supreme Court can say no on any issue of public importance. That the President says, यार तुम बताओ ना, homosexuality के लिए civil rights देते हैं, तुम बताओ. The Supreme Court will understand that you're trying to fire the gun on their shoulder, so they may not get into it, right? But if there is an issue with respect to a law which has an obligation today, and the law was pre-independence, then the Supreme Court has to really get into it. Like, for example, let us say in 1940, we told Sri Lanka that we will give you Bihar as a gift. Right now, and we said that we'll give you the gift in 2022. Somebody signed a treaty with somebody. Now, in 2022, Sri Lanka comes and says, hey, give me Bihar. Then the government has to take the opinion of the Supreme Court, and the Supreme Court's opinion will therefore be compulsory. They can't say no to that opinion. Article 145 gives the power to frame rules regarding the conditions on which a person can practice before a court. This is a very small provision. 227, wherein the High Court will have superintendence over all courts and tribunals throughout the territories in which it exercises jurisdiction, except from, of course, armed forces tribunals, which is why the confusion happens with the regional benches of the National Green Tribunal. Right? Article 246 clause 3, where it ensures that the state's exclusive powers are pertaining to the state list, and if somebody tries to encroach them, or if the state tries to make a law which they can't, then of course the courts can get into it. And then 251 and 254, we'll cover this in center state in our next set of classes. In case there is a conflict between central and state law, the courts can get into it. And of course, 372 clause 1, wherein pre-constitution legislation, such as Indian Penal Code, which is 1860, you can still judicially review it, because at the end of the day, it's a British law, but it is still being implemented today in full form and spirit. Okay, so these are what had to be covered. Now, once we understand these, we now move on to basic mains related questions. Does judicial activism undermine parliamentary democracy, or has it taken over the executive or the legislature? See, judicial activism has two basic problems. First, lawmaking is the legislature's problem, not the court's problem. And two, judges are neither elected by the people nor are answerable to the people in any manner. You can't protest in front of the Supreme Court and expect the Supreme Court to listen to you. They will not. They are a very, very cold bunch. And therefore, courts are not representative bodies. They are not competent enough to know what the people want. They are not representatives. They are not functionally equipped to understand the pulse of the people, right? So that's something for a lot of these issues. Clear? Understood? All right. Now, since also several judicial scholars and judicial sort of experts always believe that judicial activism is still democratic, because the judges have to explain their reasoning through their judgments, that we are declaring right to privacy as a fundamental right because of ABC reasons, and those judgments are matters of public record. You and I and anybody can access those judgments, read those judgments, and we can also have an opinion on those judgments. Interestingly, if the opinion crosses a line, it could also have an issue with contempt of court. So while you can agree or disagree with the judgment, it has to be done in a reasonably restrictive manner. Okay. And of course, if the reasons are wrong, the decisions are criticized, then you may have to reconsider your judgment, which is exactly what happened during the emergency when the Supreme Court had, in one of their darkest decisions, rejected habeas corpus, saying that it's an emergency and those are political compulsions. Supreme Court was severely criticized, severely. And the next time they got an opportunity to correct their mistake, they immediately overruled it. And they have a better law today. So that is, of course, something which is an absolute reality in India today. Now, beyond this, when executives and legislatures are apathetic, right, when they are not able to perform their duties, the bureaucracy is indifferent to how it works, the judiciary unfortunately can't take a blind eye, and they shouldn't take a blind eye. At the end of the day, it is a nation that belongs equally to the judiciary, the legislature, the executive, and almost everybody. So if it belongs to everybody, then everybody should have a role to play in this ecosystem. Okay, so that is that. Now, let's look at judicial review and activism with some detailed examples. Okay, so let's say in the Kesananda, Golaknath, in the Vishaka cases, abolition of adultery, decriminalization of 377, abolition of triple talaq, protection of environment and ecology, abolition of bandit labor, ban on smoking, Olga Tellis' slum dwellers. The courts have outlined Article 21, have extended the ambit of Article 21, and have included shelter, creation of collegiate system in the judges transfer case, which was the first judge's case, the second judge's case, the third judge's case, the institutionalization of PILs, providing midday meals to school children, in terms of mandating how midday meal must be integrated with the right to education, giving better guidelines on Witness Protections Act. There have been several examples of judicial review and judicial activism, and there's a bunch to choose from, right? Now, what is also now started happening is courts, while they're hearing a case, while they're looking into the validity of a law, while they're getting into the implementation of the law, they have also started issuing interim directions. Now, how the law should be better implemented, right? How the I will discuss Prakhar this in when I discuss the Supreme Court powers, not at the moment. So interim it's not binding on the president, by the way, using interim discretions or in interim directions. Now, for example, in the Shriram fertilizer gas case, it ordered the plant to be closed down. End of discussion. In the Dehradun quarrying case, it closed down limestone quarries in Missouri. It ordered the government to appoint to look into issues of bad loans, your NPAs. It ordered the UPA government to set up a special investigation team to look into black money, and of course asked them to create a new policy. So when you look at these sort of examples, this was an existing issue. This is to better implement an ongoing issue. The court will look into it, but in the meantime, this is what you should be doing. So committees have to be set up, policy guidelines are given, and that is why it has become too adventurous and sometimes have become too questionable. Like a liquor ban, like imposition of patriotism and national anthem while you have to play it in a cinema hall, setting up a Lodha committee to reform the BCCI, which is a private body. I mean, that has very little jurisdiction to begin with. So there are some examples that you can write in your mains answers. ये प्री में बिल्कुल नहीं पूछेंगे, हिम्मत नहीं है, क्योंकि ये बहुत सब्जेक्टिव है. कोई बोलेगा ये एक्टिविज्म है, ये रिव्यू है, कोई बोलेगा ये रिव्यू है, ये एक्टिविज्म है. ठीक है. Now, let's understand a little bit of context to this. See, the concept of judicial review, अब ये मेंस में लिख सकते हो. The concept of judicial review was first used and developed by the American Supreme Court in the Marbury versus Madison case. Anybody who's gone to a law school would have heard of the Marbury and the Madison case. Marbury versus Madison case. Now, in Shankari Prasad, Indira Gandhi, Kesananda, Sajjan Singh, Minerva Mill, they've all been applications of judicial review, where of course you looked at validity of land reform laws. In L. Chandra Kumar, the court actually gave 3 dimensions as to why this must exist. They said it must to ensure justice in executive action, to safeguard fundamental rights, and to decide issues of legislative competence between the union and the states. Apart from this, with respect to bonded labor, the Bandhuha Mukti Morcha, the Nija Chaudhary and the People's Union for Democratic Rights, Murli Deora versus Union of India, banning of smoking in public places. These are all elements of it. And then, of course, judicial overreach, such as there was a very good movie called Jolly LLB. It was banned in a certain context because it showed the government in a bad light. So proactive censorship of it, the National Judicial Appointments Commission issue, the Shyam Shankar Choksi versus Union of India, where the Supreme Court basically said that the cinema halls and the film case, the Tamil Nadu versus Balu case, where the Supreme Court said that road safety ka problem hai, people come, drink and have accidents. So no liquor to be served within 500 meters of any national or state highway. So what people in Gurgaon did was, this is NH8. This is a place in Gurgaon called Cyber City. It's used to be quite fun, now it's not. So this is right next to the NH8. This is Delhi, this is Gurgaon, so this is your NH8. So people, now what they did was they made a 500-meter long road in and around Cyber City to get there. So of course, these are examples and they will exist in a certain amount of context. Okay? आप ही लोगों को जाके enforce कराना होता है और कुछ नहीं. So what is our primary conclusion to the matter? Our primary conclusion to the matter is, exam में लिखेंगे, that it is inevitable and the judiciary has to do this on proper exercise of public power. Having said that, there is a thin line of difference between activism and overreach, just as the independence of the judiciary is not a part of the basic structure. The primacy of legislature is just as how independence of judiciary is basic structure. Parliamentary democracy and the ability of the parliament to make laws the interference of the court should not be allowed is should and equally a part of basic structure, and therefore society at large should not abuse this process. Take it in the right spirit. Don't use the Supreme Court as a medium to get fame, to get the government to kneel down. It is something that must take its own time. Nobody is saying that the judge should not be an activist. Sometimes activism is necessary, but it should be only in exceptional cases. And ordinarily, the judges should be very controlled in their judgment. Because when you have such judicial legislations, you further dent the constitution. And that is why a legal norm is required by society for the smooth functioning of it. So because for some reason, if legislature is unwilling or it is not wanting to make a law, then you should come in and fill a gap. You should fill a gap. You should not be the one creating the gap unnecessarily. And therefore, given the crucial role of the judiciary in the protection and the evolution of the law, it is important that the judiciary desists or stops itself from making ad hoc decisions without the backing of sound principles, particularly when the decision appears to break law grounds or break new grounds. Do it in the right manner. Do it when it's absolutely essential. What you could write is, the Supreme Court must apply the principles of essentiality in determining how essential is it that it requires judicial activism or judicial overreach. Judicial review is something which is necessary. It keeps checks and balances in place. ठीक है? My favorite statement, अगर एग्जाम में आएगा तो इतना ही आएगा, इसके ऊपर नहीं आएगा, आप कुछ करके देख लो। इसी को 10 बार पढ़ना है, मीन्स में न्यूज़पेपर से कोई एग्जाम्पल आएगा, इसी में ऐड कर देना है, बट कहानी यहाँ खत्म हो गई, बस। Nothing else from judicial review, judicial activism, judicial overreach is going to come. सही है कि नहीं है? सही है कि नहीं है? Correct? We just have to keep adding more examples. गलती से कोई एडिटोरियल आ गया, उसमें किसी ने अच्छा सा पॉइंट बता दिया, तो हमने यहाँ पॉइंट लिख दिया, बस खत्म। That's it. ठीक है? You must understand, it takes a lot of research. It takes a hell lot of research, to get into it. आपको पता है ये एक लेक्चर तैयार करने के लिए, I'll show you, ये एक लेक्चर तैयार करने के लिए these are the books that have to be referred to for one lecture. The Landmark Judgments of the Supreme Court by Senior Advocate Dewan, a dedicated book on judicial review by Justice Narayan, Supreme Court guidelines which have been issued till date, a lovely set of books written by Rohinton Nariman, 2 volumes, Discordant Notes Volume 1, and of course Discordant Notes Volume 2 for one lecture. Okay, so that you get the best arguments from the best places in one place, और आपका खत्म हो गया। आया समझ में? Clear? All right, we can take a 5-minute break. Thank you. No, this is just to tell you that all possible arguments that I could get are now in one place, and it's taken care of. ठीक है? Thank you. See, I always believe that this is where I spend 12 hours a day. Like how you spend 12 hours a day in your room. I always tell you, instead of staying right next to a coaching, instead of really spending spending money on, say, house right next to the coaching and all, stay a little away, invest in your room. You're going to spend 12 hours a day studying in that room, another 8 hours a day sleeping. You have to be comfortable, है ना? तभी मन करता है पढ़ने का बैठ के, है ना? इसलिए ठीक है. अब देखो मैंने किताब दिखा दी, अब आपको लगा ये बहुत पढ़ते होंगे. पढ़ता मैं हूँ, बट दैट्स द होल पॉइंट. यही नहीं करना एक्टिविज्म में, ठीक है? ओके, गुड. सो हमारा खत्म हो गया, बस इतना ही है. एग्जाम में इसके बाहर आएगा नहीं. इसमें हम बस पूरे साल भर में एग्जाम्पल्स आते रहेंगे, न्यू आर्ग्यूमेंट्स आते रहेंगे, वो हम इसमें ऐड करते रहेंगे. ठीक है, अंडरस्टूड दिस? गुड. अब एक छोटा सा सेगमेंट और बचा है, विच आई विल इमीडिएटली कवर एंड देन विल बी डन, विच इज योर PILs. ठीक है, बिकॉज PILs ऑल्सो सर पे चढ़ते हैं. So let's understand this. There are some things left with respect to PILs. एक बार मैं ना अच्छे से आपको कराना चाहता हूँ, and then of course there's ADR which I will do in judiciary later on. But मैं PIL एक बार कराना चाहता हूँ आपको, भी इसी का extension part ही है. ठीक है, बहुत आसान है. There's nothing to worry about. So let's spend some time. Okay. Thank you, Ekansh. Union and federal. Union is central government. Federal is a country which has both center and the states. Yes. हाँ, मतलब it does take a little bit of time, but it is beneficial. Then I also know इसके ऊपर हमें जाना नहीं है, इसके ऊपर हमें कुछ और करना नहीं है. ठीक है? All right. Okay. Now let's look at how PILs can be initiated and so on and so forth. See, a citizen can file a public case by filing a petition under 32 to 26 and of course under 133 of the CRPC in the court of the magistrate. Now this of course is not particularly relevant to PILs, but अगर आप एग्जाम में ये एक एक्स्ट्रा पॉइंट लिखोगे ना, examiner will know that you understand what a public case is. A public case is when you're filing a case on behalf of somebody, that you felt very bad in the winters seeing how the homeless in Delhi are shivering, and that is why you filed a PIL saying that there should be shelters for them, right? The court must be satisfied that the writ petitions fulfill certain basic needs. Now, because PIL is a very simplified procedure, even a letter is okay as a writ petition as long as it is addressed by an aggrieved person or a public spirited individual or a social action group for the enforcement of constitutional legal rights, or a group of people for poverty, disability, socially economically disadvantaged. अब ये challenges to sedition, your PUCL cases, ADR cases on election reforms, all of these are basically PILs. Or in fact, yes, absolutely, Abhijit. So I will. So a PIL is, in fact, when I give you the numbers of PIL, I'll give you the 2021 numbers of PIL. The number of PILs that you get in the courts of India is absolutely unimaginable. You can't even think about it to the context that there is. Now, let's understand this. On an average, the Supreme Court receives 25,000 PILs on a yearly basis. 2019 was the highest record of PILs which were filed in the Supreme Court. 70,836. Okay. Now, the Supreme Court does not admit all the PILs, does not listen to all the PILs. They can reject half the PILs. But the sheer number of PILs that the Supreme Court receives, it's just huge. You can write a letter to the Supreme Court today कि देखो ऐसे हो गया तुम्हारा PIL, खत्म. Right, but it's written properly. Now, the first PIL was admitted in 1979 in the case of Husainara Khatun versus State of Bihar. This was basically for under trial prisoners who had been, in jail longer than they should have been, even if they were convicted for the crime that they had committed. कि maximum jail time का crime का 5 साल था, अब 15 साल से जेल में हो. Basically under trial prisoners, right? Now, more recently, it has been used to bring to court matters pertaining to migrant to the plight of the migrant children during the pandemic, constitutionality of the Muslim marriage practices, the need to update abortion laws. These are some of the more recent PILs that have been filed. In January only, they filed a PIL again for challenging the constitutionality of sedition, which the Supreme Court has put on hold very, very recently. And these letter petitions and writ petitions are also entertained as PILs. Letter petitions are in fact far more frequent because writ petitions have to be formal in nature. They have to have a certain amount of what is called legal structure, procedural structure. But in this case, aap chitti likh do, which is why out of these 25,000 PILs, more than 90%, more than 80-90% are letter PILs. चिट्ठी लिखिए बस, ठीक है. Letter petitions also allow the general public to approach the court easily, where of course your writ petitions have to be legally very, very clear. There are certain political considerations and so on and so forth. ठीक है. Now, इतना हमें समझ में आया. अब PIL usually होता कहाँ पे है? Let's understand this. You will mostly see PILs with issue of bonded labor, neglected children, casual workers exploitation, non-payment of minimum wages, atrocities against women, environmental pollution, food adulteration, management and maintenance of heritage and culture. Usually यहाँ पे होता है. I'll give you some landmark cases. Hussain Ana Khatun, we spoke of under trial prisoners, the first ever case. MC Mehta, several cases for environmental preservations by the way of PILs. Vishakha was in fact a PIL which led to judicial legislation, which is a form of judicial activism. And the Parmanand Katara was a union of case where it basically said that if you're a doctor and you've received a patient injured, okay, give them treatment first. Listen, basic Munna Bhai issue. कि फॉर्म मर रहे हैं तो भरेंगे कैसे? So that, and for example, Good Samaritan and all of those kind of concepts have come through PILs and PILs only. Okay, बहुत आसान है. इसमें मतलब कुछ इसमें कोई complex नहीं. बस आपको पता होना चाहिए कि हम क्या कर रहे हैं. Now there are certain advantages and there are certain disadvantages to PILs. First, it of course gives you fantastic access for redressal to all, especially poor and marginalized, balance of law and justice. It allows for justice for economically challenged sections, provides a platform for them, implements judicial review, it ensures judicial monitoring of state institutions, it democratizes justice, raises awareness, and allows for judicial monitoring of state institutions. इससे कुछ नहीं करना है. जुडिशियल रिव्यू और जुडिशियल एक्टिविज्म के एडवांटेजेस में बस डेमोक्रेटाइजेशन ऐड कर देना है, एक्सेस टू जस्टिस ऐड कर देना है. योर एडवांटेजेस रिमेन द सेम और यहीं पे डिसएडवांटेजेस भी आर वेरी सिमिलर. That competing rights happen. Like for example, when one society, for example, as you file a PIL, that this infrastructure project should not be made in the village because it is going to cause environmental destruction. But this infra project, which was a highway, would have given so much trade and travel. So it's about one interest versus the other interest. Like for example, shutting down of polluting industries leads to loss of daily wages. Similarly, frivolous cases can be filed by parties without heavy court fees, and this is often politicized that you can hire NGOs to go to court and then they will represent the matter, stay lag jata hai, and so on and so forth. And then of course there's a potential for judicial overreach, which violates the doctrine of separation of powers because you're getting into executive domain. And finally, you have a lot of delays in public interest litigations. तो ये basic है advantages, disadvantages. Same होना चाहिए that you should use it in exceptional cases only when it is necessary. ठीक है, बस खत्म. आपका सेपरेशन ऑफ पावर्स, चेक्स एंड बैलेंसेस, आपका मेंस का थर्ड वाला टॉपिक कंप्लीटली खत्म. नाउ लेट मी शो यू हमारा क्या क्या बचा है, सो दैट यू अंडरस्टैंड कि हाँ भाई लाइन गाड़ी सही लाइन पे चल रही है. ये आपका सिलेबस है। ये खत्म, ये खत्म, ये खत्म। अब एग्जीक्यूटिव खत्म, जुडिशरी बचा है, इलेक्शन रिफॉर्म्स, बॉडीज बचे हैं। ठीक है, इलेक्शन रिफॉर्म्स एंड बॉडीज आर लेफ्ट। आई हैव ऑलरेडी शेयर्ड अ PDF विद यू ऑन दिस। एक बार उसको देख लेना, हम क्लास के बाद में रिवाइज भी कर लेंगे। इसमें भी हिस्टोरिकल अंडरपिनिंग्स का हो गया है। सो वी आर लेफ्ट विद सेंटर, स्टेट एंड लोकल। वी आर लेफ्ट विद द जुडिशरी। We are left with elections and as a context of it, bodies. बस इतना ही तो बचा है। देखो, खत्म। वो डिस्प्यूट रिड्रेसल हम जुडिशरी के साथ ADR पे मर्ज करके करेंगे। Yes or no? ठीक है, खत्म हो जाएगा यार 12 तारीख से पहले। आज क्या है, 5 है आज। $133 is nothing but going to the magistrate for a larger issue affecting society. You can Google it also. Class action litigations, no. CPC does not specifically permit for the same.